In this video, we'll look at the next place where contract law, and in particular the UCC, supplements the express terms of an agreement, the implied duty of good faith. Sometimes you'll see this duty referred to by different names, including the implied covenant of good faith, the implied contractual covenant of good faith, or simply the duty of good faith. And in addition to good faith, the name may or may not have fair dealing appended to it, so it may be referred to as the implied duty of good faith and fair dealing. Whatever jurisdiction may call it, they're all talking about the same thing. Every contract imposes a duty of good faith and fair dealing in the performance and enforcement of that contract. That's true of all contracts, whether a contract is governed by the common law of contracts or whether that contract is governed by the UCC. In particular, Article 1, Section 304 imposes on every contract a obligation of good faith in its performance and enforcement. Note that this is an implied duty, a duty that's implied by law, or in this case by statute. In this respect, this is a legal obligation that goes beyond what the parties expressly agreed to. And because it is a statutorily imposed duty, it is an unwaivable duty, a duty that will always supplement whatever the parties agreed to. What's the scope of this statutorily imposed duty? Well, there are two relatively straightforward points that we can make clear at the outset. First, as made clear by Comment 1 to Section 304, the duty of good faith is not some kind of independent, free-floating duty that applies to the parties to a contract. In particular, Comment 1 says that this section does not support an independent cause of action for failure to perform or enforce in good faith. Rather, this section means that a failure to perform or enforce in good faith a specific duty or obligation under the contract constitutes a breach of that contract. This distinction makes it clear that the doctrine of good faith merely directs a court towards interpreting contracts and does not create a separate duty of fairness and reasonableness which can be independently breached. So the duty does not create a general obligation of fairness or good faith, the breach of which creates an independent cause of action. Instead, it is a lens through which the express terms of an agreement are to be interpreted. The idea is that whenever a party is performing its obligations under a contract, or enforcing its rights under that contract, that party must act in good faith, and the failure to do so is a breach of that contract. In this respect, the duty of good faith is more of an interpretive tool and not some independent duty arising under the contract. And because it is merely an interpretive tool and not an independent duty, the implied duty of good faith cannot contradict the express terms of a contract. After all, the duty is supposed to add an interpretive gloss onto the express terms, so it necessarily cannot contradict those terms. The second point we can make is that temporally, the duty attaches only once a contract has been formed. Because the duty applies to the performance and enforcement of a contract, there must be a contract before the duty exists. Stated differently, prior to contracting, before there is a contract between the parties, there is no obligation of good faith. There is no general duty to act in good faith in the process of negotiating a contract before a contract is actually reached. Going beyond these basic points, the far more difficult and important question regards the substance of the duty. What does good faith mean? You should by now be used to hearing me say this, but it bears repeating. As with any term used in the UCC or any other statute, the first place you should look is to the statute itself to ascertain the meaning of the terms used. In this case, Article 2 defines good faith in Section 103, subsection 1b. This section defines good faith to mean honesty in fact and the observance of reasonable commercial standards of fair dealing. But note this definition applies to merchants only. It says nothing about good faith as applied to non-merchants. To understand the definition of good faith as applied to non-merchants, we must look to the definitions section of Article 1, Section 201 of Article 1. Remember, the provisions of Article 1, including the terms defined therein, apply to all of the other articles of the UCC, including Article 2. As we've discussed in a previous video, the current version of Article 1 was promulgated in 2001 and has been adopted by all 50 states since. And one of the changes made by the revised Article 1 was to adopt the definition of good faith used by Article 2 for only merchants, and to apply that definition to all parties, merchants and non-merchants alike. Thus, under Article 1, good faith is defined generally as honesty in fact and the observance of reasonable commercial standards of fair dealing. In effect, the revised Article 1 creates a uniform standard of good faith applicable to all contract parties, both merchants and non-merchants. As a consequence, revised Article 1 makes the separate definition in Article 2, Section 103, which applies only to merchants, superfluous, because the merchant-only definition is now consistent with the general definition set forth in Article 1. As we said, the current version of Article 1 was promulgated in 2001 and has been adopted by all 50 states. But when enacting the revised Article 1, about a dozen states, but not Oregon, adopted some non-uniform variations to the revised model statute. And the most common non-uniform variation was to retain the old definition of good faith, the definition that existed under Article 1 before its 2001 revisions. The old definition of good faith bifurcated the meaning of good faith between merchants and non-merchants. For merchants, the old Article 1 used the same definition of good faith that we saw in Article 2, and that the revised Article 1 now applies to both merchants and non-merchants. For non-merchants, the old Article 1 used a relaxed standard for good faith, requiring only honesty in fact and not the observance of commercial reasonableness. So even though the current model statute uses a unified standard for good faith, in practice, the definition of good faith depends on the law of the state that you are interested in. Whether a state has adopted the unified definition of the model statute or a non-uniform bifurcated definition of good faith, the definition itself is not terrifically helpful. After all, what does the statute mean by honesty in fact and commercial reasonableness? The duty is generally understood to have two separate components, as noted in the Roth Steel Products vs. Sharon Steel case in your reading. The subjective component of good faith stems from the statutory requirement of honesty in fact. In this context, good faith means a party to a contract, in enforcing her rights or performing her obligations, cannot act dishonestly or opportunistically. Stated differently, cannot act in bad faith. Essentially, subjective good faith gets down to a question of a party's subjective motives. Did the party act with legitimate reasons in mind, in which case she's acting in good faith, or was the party motivated by some illegitimate considerations, in which case the party was not acting in good faith? The second component of good faith stems from the statutory requirement to observe reasonable commercial standards. In this context, good faith means a party to a contract in enforcing her rights and performing her obligations must act reasonably, as judged from a commercial standard. She must conduct herself in a manner that is consistent with the reasonable or justified expectations of the other party to the contract. Sometimes courts apply a hypothetical bargain analysis to the question of objective good faith. To determine whether a defendant's actions breached the objective standard for good faith, a court may ask whether the parties to the contract would have expressly prohibited the defendant's actions had they thought to address it ex ante, when they were originally negotiating and drafting the terms of the contract. If so, then the defendant's actions breached the objective standard of good faith, even if those actions did not breach the express language of the parties' agreement. If not, however, then there is no breach of good faith. Of course, because the hypothetical bargain analysis is based on a hypothetical counterfactual scenario, it largely just reflects the court's own equitable intuition about whether the defendant's conduct should be permitted or punished. There are two common scenarios where courts tend to apply the implied duty of good faith. One is when one party to a contract takes an action that is not specifically prohibited under the express terms of the agreement, but that interferes with the other party's ability to perform its obligations under the agreement. The other typical scenario is when one party is empowered to exercise discretion under the contract, but the party exercises her discretion in a way that is dishonest or based on illegitimate motives, or that is simply inconsistent with the reasonable expectations of the other party. Consider this example. Press pause to read this example clause. This express term gives the buyer discretion to inspect the goods the seller provides and reject any of the goods that the buyer finds to be unusable. So buyer has some discretion in exercising this express contract right, whether to accept or reject the seller's goods. But note what the contract does not say, that the buyer can exercise that discretion in its sole and absolute discretion, for any reason or no reason whatsoever. The parties could have agreed to this language, but they did not, likely because the seller would not have agreed to it, because it would have put the seller in a position of significant vulnerability at the hands of the buyer. In the absence of that kind of express contract language, the implied duty of good faith limits the buyer's discretion in exercising its express contractual right, by limiting that express contractual right to the buyer's reasonable discretion exercised in good faith. And that in a nutshell sums up the implied duty of good faith, that in the absence of an agreement to the contrary, it is a legal presumption that both parties to a contract intend that each will act honestly and reasonably toward one another. But it is a rebuttable presumption, one that may be limited by the express language of the parties' agreement. So that completes our look at the implied duty of good faith, another term which the UCC adds to contracts. In the next video, we'll examine the most complex topic in this week's module, modifying the terms of an existing contract under UCC Article 2.